Good afternoon, everybody. My name is Ranger Chris, and I'm with the James A. Garfield National Historic Site. And I'm going to be speaking to you today about James A. Garfield and his landmark Supreme Court case of Ex Parte Milligan. Today, for clarity's purposes, I'm only offering a historical perspective of the case and its impact on some later court decisions. To kind of understand what we'll be talking about today, you have to comprehend the situation in which the law came about and how it evolves over time. So, you can all see my screen, hopefully, here. And to understand the weightiness of this case, you have to get a sense of what Americans must have felt throughout the war. It was a terrible conflict, obviously. After nearly 40 years of compromises between the southern states, where slavery was legal, and the northern states, which outlawed slavery, the election of Abraham Lincoln by a majority of electoral votes broke the camel's back. Lincoln's votes came entirely from free states, which sent the South, again, slaveholding states, into a tailspin. They quickly realized that from then on, the president could be determined by the North without any sort of assistance from the South, which made Southerners believe there was only one conclusion after all, which they thought was secession. When Abraham Lincoln is inaugurated on March 4th, 1861, the Deep South, comprised of South Carolina, Florida, Georgia, Alabama, Mississippi, Louisiana, and Texas, have already seceded, and they declared themselves a confederation of sovereign states, and that this newfound confederacy demanded that the Union abandon Fort Sumter, an island fort off the coast of Charleston, South Carolina. And when Lincoln and his cabinet are deliberating about what to do, Southerners gave them no choice. Firing batteries from shore, the South will lay siege to a fort that garrisoned American soldiers, which in most eyes in the Union was an act of rebellion. So, after 2 days of bombardment, the 85 Union troops surrender, and after a solemn surrender, the Civil War begins. Unbeknownst to every American, the Civil War is not going to be a short affair. In fact, it's going to last 4 years and will be a scene of intense combat, leaving somewhere between 620,000 to 720,000 troops dead. It remains the deadliest war in American history. The war is a turning point for American history. It might be, in fact, the turning point in American history. And following the siege of Fort Sumter, it doesn't take long for North Carolina, Tennessee, Arkansas, and frankly, most importantly, Virginia, to turn on the Union, leaving the nation's capital, Washington, D.C., exposed to attack. No longer safely within the country's interior, but as a capital on the border of war, Lincoln calls for his first round of 75,000 troops from the North. Now they'll have to pass through into Maryland here, which is a slave state which had remained loyal to the Union, but there were, Confederate sympathizers is a good way to describe it, who blew up bridges in Baltimore leading from northern cities. And Lincoln and his Secretary of State, William Henry Seward, will suspend the writ of habeas corpus in an area corresponding to the railroad line. Now let's take a moment, just pause and talk about what habeas corpus is, because it's something we'll hear about time and again through our little talk here together. Habeas corpus allows somebody who's imprisoned or detained by a government official to have a court look into the basis of the detention. And if the court finds that they've been unlawfully detained, they can free someone who's been unlawfully detained. So this obviously is a big thing here, and we'll see how that plays out. Leading back to the Civil War, so federal officials arrest a guy by the name of John Merryman, who he is claimed to have destroyed one of the bridges leading to Baltimore from the north. Merryman will challenge the arrest by questioning whether the suspension of habeas corpus is constitutional. This question is one of the legal principles which will again return into Ex Parte Milligan. So when he's arrested, Mr. Merryman sues for writ of habeas corpus. His case was heard almost immediately by the Chief Justice of the United States Chief Justice of the United States Supreme Court, Roger Taney, who's pictured here. He's the author of the infamous Dred Scott decision and was acting as a circuit justice in Baltimore at the time. Mr. Merryman argues that because the only reference in the Constitution regarding habeas corpus is in Article 1, which deals with the powers vested in Congress, not the president therefore could not suspend the writ of habeas corpus alone. This provision Merryman cites is in Article 1, Section 9, Clause 2, which says, the privilege of the writ of habeas corpus shall not be suspended unless in cases of rebellion of invasion and the public safety may require it. So, again, being found in Article 1, this is going to be central to Merriman's argument. Chief Justice Taney agrees with Merriman in his opinion, and that Lincoln, without the aid of Congress, cannot suspend the writ. Now, President Lincoln was a lot of things. And for a man who was born into a log cabin and had, maybe a year of formal education, was an incredibly intelligent man. There are many historians who will agree that Lincoln was truly one of the great geniuses who's identified throughout the war, and this is a great example of it. So, though he started out as a backcountry lawyer, he was a brilliant jurist and a pretty crafty politician. Lincoln would turn the issue of habeas corpus into an issue of civil liberty in wartime. By 1862, the president would again push the issue, as he had the Secretary of War, Edmund Stanton, issue another set of executive orders, including suspending the writ of habeas corpus, authorizing temporary military detention for civilians, and allowing the government to bring civilians to trial before military tribunals instead of civilian courts. Here we have a picture of the military tribunal that was ultimately try Milligan. So let's talk military tribunals for a moment, which are also known as military commissions, and I'm going to use that term interchangeably from here on out. They usually refer to a court that asserts jurisdiction over persons who are members of an enemy military, are held in military custody, or are accused of violation of the laws of war. So by suspending habeas corpus, the Lincoln administration thought, at least hoped in this case, that would prevent the stopping or slowing down of swift justice as the Union furthered their war effort. Prosecuting civilians, though, in military tribunals is kind of a smaller slice of a big pie, which is called the civil liberties of wartime. In a lot of respects, the Civil War was the perfect breeding ground for issues relating to civil liberties in wartime. Although the United States had conflicts prior to the Civil War, in the War of 1812, where obviously it was fought on the United States homeland, the federal government was probably too weak to challenge civil liberties against Americans. And the Mexican-American War was fought almost entirely in foreign territory and thus didn't really impinge on the American civil liberties to a great extent. But the Civil War, however, was a massive conflict that was fought over 1,000 miles front and saw battles occur in over 10,000 places, which makes it a pretty darn good place to find conditions to make civil liberties a struggle between Americans and their government. So in no moment were civil liberties more tested than during the course of the war than in the case of ex parte Milligan. In the summer of 1864, Union authorities hear a rumor of a conspiracy by Southern sympathizers in the North who, calling themselves several names before they settle on the very popular term, the Sons of Liberty, who hope to raid a federal arsenal at Rock Island, Illinois, to free Confederate prisoners, which are in a camp outside of Chicago, and they hope to assassinate the governor of Indiana, Governor Morton. One of the members of the Sons of Liberty was a man by the name of Lambdin P. Milligan, pictured here, who was an outspoken anti-war Democrat, a lawyer, and was often openly critical of the Lincoln administration. He had sought, and he had stated this multiple times, to, quote, defend Americans against despotism. Mr. Milligan was a civilian, through and through. He had never taken up arms for or against the United States. He lived in Indiana, a state which was not in rebellion, and he had been there since 1845, so almost 20 years, actually over 20 years by the time he's prosecuted. So Milligan, however, was, like I said, an open partisan who long supported positions that would probably be more emblematic of a Southern sympathizer. When South Carolina had been a proponent for nullification of federal law, Milligan stood by them. He also had extreme stances on states' rights and the Union's prosecution of the war in general, which he thought was far too overbearing and that the South should be able to lawfully secede. Perhaps because of these outspoken stances, he was solicited by an agent of the Sons of Liberty who, colluding with Confederate agents in Canada, wished to free arrested draft dodgers and anti-war protesters and use them to start an uprising in the Union's rear. Other historians have argued that instead they wished to break off into a Northwestern Confederacy, which would split the Union again. The goals are not exactly clear, but at some point during these conversations, it's known that Milligan and this agent exchanged advice and money, and that the Sons of Liberty's plans would ultimately be thwarted when federal officials found incriminating letters and a cache of arms in the home of one of the commanders of the Sons of Liberty. Now, Stanton, again, Lincoln's Secretary of War, who was a hard man by all accounts, ensured that the accused would be tried in a military tribunal by senior officers instead of a federal court where a jury would be there, as was the normal procedure. You only can conject that Stanton probably did this to make sure that it was quick and expedient and that he got the result he wanted. The trial took several weeks, and the tribunal found all of the defendants guilty, and sentenced 3 of them, including Lambdin P. Milligan, to hang. By this time, Lincoln is reelected, and Atlanta, Georgia has returned to Union control. Now Sherman and his army are marching through to Savannah, and Lincoln's feeling pretty good. He's reflecting the public's lenient views, and he actually sits down and meets with Milligan's lawyers. And he gives them a sense that he was likely to commute their sentence before the execution. And if you're Milligan, this is a great thing. This means that you're probably not going to have a necktie party you have to visit, and that all things considered, you're going to get off essentially scot-free. However, a small unfortunate event happens for Mr. Milligan and the whole of the Union. Lincoln's assassinated, which leaves a new president, Andrew Johnson, who is by no means the same crafty man that Lincoln was, and Andrew Johnson's sentences are carried out. So what do the defendants do? They'll go to a federal court in Indiana. They'll seek a writ of habeas corpus, which we've now talked about. And you may recall that, as I said, Stanton had suspended that in 1864, which brings us to the climactic case of ex parte Milligan. Unbeknownst to Milligan or his lawyers, they had an ally looking for a case exactly like this. And that was the Associate Justice of the United States Supreme Court, David Davis. Justice Davis was an old friend of Abraham Lincoln. In fact, he was Lincoln's campaign manager at the 1860 Republican National Convention. Lincoln and Davis had been political allies back when both were in the Whig Party, which shaped them in different ways. While Lincoln would from time to time bend the rules for wartime necessity, Lincoln was very much true in his Whig ideology, and that he saw the law as unbending, regardless of whether the country was in the midst of civil war or not. The Whigs, as a party, oftentimes saw themselves that you change the law, you don't try and bend the law to your interpretation. And so the civil liberty issue is one which both parties throughout the war had grown increasingly uneasy with. The Democratic Party used the infringement of civil liberties as a main plank in their party platform in 1864. And in 1865, Republicans tried to pass an amendment to an appropriations bill that would have banned trials by military commission altogether. The Republican amendment was actually drafted by Justice Davis's cousin, and once that failed, Justice Davis was pretty sure that he wished to insert the court into the issue. So to do so, it served on a circuit court to answer that writ of which Milligan was applying for, and he then arranged the judges on that court to disagree whether answering that petition was legitimate and whether Milligan should be released. So this is a brilliant legal tactic by Justice Davis, as federal law in 1865 will state that when 2 judges on a circuit disagree, it automatically went to the Supreme Court. Can you imagine that today? Now, this is how a sitting justice of the United States Supreme Court would bring a case to the court where he could then rule on it. It was obviously a brilliant legal maneuver on his part to get the case that he thought was most important right before him. And people agreed with him. It was universally accepted as an interesting case, and the court assigned 7 whole days for oral argument. This wouldn't be an easy argument, though. Both sides would step up to have, the best legal teams they could find. The government had prominent lawyers, including Attorney General James Speed, whose principal qualification, however, seemed to be that he was the brother of a close friend of Lincoln's in Kentucky. Joining him was also as a joining attorney counsel was his co-counsel, a former attorney general of the United States, Henry Stanbury, who's from Ohio, and Union General Benjamin Butler, who was most famous for his occupation of New Orleans, and still to this day can be referred to as the Beast by some in the South. All three of them were lawyers. General Butler seems to be the odd man out, but he was considered a really brilliant trial lawyer, and they thought that that was going to be a good addition to give them a little bit of wartime experience. Now, representing Milligan and the other defendants was an equally all-star team. We had Jeremiah S. Black, who was the Attorney General and Secretary of State under a prior president. We had David Dudley Field, who's the brother to a sitting Supreme Court Justice Stephen Johnson Field. We had Joseph E. McDonald, and a young congressman and former Major General, who in fact was the youngest Major General when he was in uniform, James A. Garfield. And Garfield was definitely the odd man out of this group. He had never tried a case before in his life, and he would later explain in his autobiographical notes how he came into the group. He said, and I quote, "When the war came, Congress came, and then in 1866, when he was about 2 years in Congress, it so happened he was in the company of Henry Winter Davis, who he much admired. And he resisted some attempt to expend the power of military commissions to give the power to the civilians who had interfered with the prosecution of the war to such fellows like Clement Vallandigham, famous Copperhead. And Garfield resisted the passage of such laws being, quote, un-American and contrary to the old English spirit of liberty." Then some of the Indiana Democrats, or in this case, Judge Black, acting as an attorney, came to Garfield and said that he had heard of some men, including Milligan, who'd been tried in Indiana for conspiracy against the government. And when tried in 1864, while the war was pending, they were put into court-martial, and Garfield hears this and decides that he wants to join the group. Now, there's a lot of interesting things that come about from this, which is that Justice Black was a hardcore pro-war Democrat. He had done so specifically and gotten involved in this case because he wanted to stick it to the Republicans. And so when Garfield is approached with this, Justice Black actually will say to him, "Are you sure, young man, that you're interested in doing so?" And of course, Garfield then asks about the nature of the case. And after a little bit of time, he comes back and says, "It doesn't matter. I believe in English liberty and English law," which he confides in Justice Black that though he's not a petitioner of the Supreme Court, that he'd like to get involved. Now, that story by Garfield is probably largely apocryphal. Garfield had actually prior, while serving as the president of the Eclectic Institute, today known as Hiram College, had made a letter to a friend back at the Eclectic Institute while serving as a general, stating that if he heard any pro-war talk at the Eclectic, he personally would have hanged the students. But in the time, Garfield clearly was looking at some point or another to transition, and starting off by litigating before the Supreme Court seemed like a pretty good way to begin a career like that. And so Justice Black asks him, "Well, how long have you been admitted to the bar?" And Garfield says, "It's been about 6 years." And Jeremiah Black will say, "That'll do." They'll take him over to the Supreme Court, have him entered into the case. And Garfield would then go on to say that he didn't really remember a lot of the people who were involved on the other side, but that he had essentially unlimited time to speak, and that he sat down and worked for 2 days and 2 nights with only 4 or 5 hours night's sleep, and wrought out his points for the argument before the Supreme Court. I think any attorney today would probably be shocked to imagine that they spent essentially 2 days working on a Supreme Court case, and that was all they were going to do. But that's how it was in Garfield's era. So the lawyers representing the defendant had long, fanciful arguments which made great references reaching back to the early years of English common law and denoting the idea of military tribunals to try civilians flew in the face of Anglo-American legal tradition. Garfield actually at certain points will cite Shakespeare in his portion of it. It's an interesting piece. I suggest you read it when you have the time, although it is a little lengthy. Now the government's argument is incredibly straightforward. They argued that the Constitution applied only in peacetime, but not in wartime. Now, take a moment to think about that. The Attorney General of the United States and his team, comprised of a former Attorney General and a general of the United States Army, argued to the United States Supreme Court, who were all respectively vested in their powers by the Constitution, that the Constitution does not apply in a time of war. And furthermore, if somebody wanted to go to find war in Indiana, they'd have great trouble, as Indiana wasn't a theater of the war. This was considered a terrible way to approach this. And in fact, it was so truly terrible that one justice would remark that the session of the court has developed Speed's utter want of ability as a lawyer. He is certainly one of the feeblest men to address this court this term. This goes as well as one may expect, and the court unanimously in favor of Milligan. Milligan gets to walk free because of this, and they agree that a military trial was unconstitutional when there were civilian courts open, and that Milligan must be released. When Chief Justice Lambdin P. assigns the majority opinion, he gives it to the conductor of his orchestra that we've now seen, Justice David Davis, who would go back to his farmhouse in Bloomington, Illinois, and wax about how to approach the case. So again, this is by 1866. So he felt dismayed about how the Civil War had changed the commitments of civil liberties like freedom of the press and depriving of life and liberty. And David wanted to do more than establish just a binding precedent for the court. He really wished to set the government's constitutional powers in a time of crisis. What he really wanted to do essentially was write an opinion for the ages here. And as the justice had said himself, no graver question has ever been considered by this court, nor one that had concerned the rights of the whole people. His opinion, which was handed down in December of 1866, nearly a year and a half after the Appomattox, held that civilians should not be tried by military commissions outside the theater of war, while courts, that are civilian courts, are open for business. His opinion continued that the Constitution does apply equally in war as it does in peace, and that military tribunals may only try civilians when ordinary law has collapsed and that there are no courts to administer justice. Mr. Milligan should have been tried in the federal court by a jury of his peers, which Justice Davis knew, had he done so, would have resulted in probably the same thing that happened when the military tribunal tried Milligan. They would have probably given him the death penalty, but it would have been constitutional to do so. Milligan had been a Hoosier for 20 years, Justice Davis notes, then a state which saw no wartime struggle. In his home, having never served on the Army or Navy of either side, he was not a combatant in any way, shape, or form. So this opinion gets put out there, and this case, which was supposed to be the most important case, at least in Justice Davis's mind, since Marbury v. Madison, in many respects was an absolute flop. Between the judgment in April and the opinion in December of 1866, the political sands shifted. What was once upholding civil rights for the little guy was now a nightmare for the government because of Reconstruction. After all, think about it. How could martial law exist when the federal courts were now open and there was no war being waged in the South during Reconstruction? By the ruling's own standards, anyone who was waging some form of a personal struggle against the triumphant Union must now be tried by an open civilian court by a jury of his peers, a jury which would be comprised of other Southerners. It didn't take long for people in Washington to figure out and ask, how could the federal government protect its power in the South and protect the rights of freedmen, Southern loyalists, Northerners moving south, and its own soldiers? President Andrew Johnson would be of no help. In fact, he would probably be the opposite of helping in this case. He released proclamations saying that peace reigned throughout the land and that the civil government was reestablished and the courts were open and unobstructed, which meant that, they couldn't say, well, it's not like the courts were really open not open and unobstructed, and that they needed to put them through military tribunal. And consequently, Mr. Johnson has now, people could cite him and say, well, your president is saying so, which created quite an issue for those trying to figure out how to enact justice in a reconstructed South. The opinion written in Ex Parte Milligan didn't say anything about Reconstruction, but it did say that military tribunals on civilians could not continue after the civil courts were reestablished. So, again, free African Americans, Southern Unionists, and soldiers would now be held accountable by Southern courts and juries. And their only other recourse would be prosecution in state courts. And Congress wasn't sure that that was going to work particularly well either. And so they needed to make a law to get those prosecutions in federal courthouses, even when juries would still be filled with Southern whites. So what a military commander could do was not haul any before a military commission. And instead, what they would have to do is try and say that they were provincial areas instead, and that's how they would get them in a way that was lawful and constitutional, and that they weren't fully reestablished. Because of this and this kind of weird workaround that the Congress had to do to try and get this Reconstruction to stay afloat, this opinion was panned from the start. The New York Times would say it was actually the worst case since Dred Scott, and obviously it was threatening to end Reconstruction before it began. So they would pass the Reconstruction Act of 1867, like I said, which made this the provisional military authority and authorized the use of military commissions as necessary to secure the rights of Americans. People have argued whether this is constitutional ever since. Congressional Republicans at the time would say yes, as peace wasn't truly restored until the states had their usual relation to the government and would need representation in Congress. And that would take a little bit of time. The first state to be readmitted was Arkansas, which would not happen for another year until 1867. And then the last one, Georgia, wouldn't do so until 1870. Now, obviously, as we know, as people interested in the Civil War and Reconstruction history, Reconstruction will continue for another 7 years until 1877. And so as people discuss this, it was kind of a nightmare when Milligan came out. Because of that, I guess you could make the argument that Reconstruction was hastened by Ex Parte Milligan, and that congressional Democrats would then be continuously trying to get a Supreme Court case which would be adverse to Reconstruction. Milligan prevented military commissions once peace was restored, but violence was still prevalent. All the acts had to be enforced in federal courts. Federal courts were ineffective in protecting the rights of African Americans and Southern white Republicans, after all. So today, it's one of those cases that's cited as one of the great cases. One textbook, which was published in the height of the Cold War, would declare Ex Parte Milligan as the difference between the United States of America and Nazi Germany and the Soviet Union. However, political scientists have not been so loving. One actually stated that Justice Chase's concurring opinion was correct, and that were Davis's opinion ever to put the test during a war, it would be overturned. And although this case was one for the ages and applied to rulers that ruled in war and in peace, the rule that came out of it was narrow and frankly rigid. Native Americans, for example, would not apply, and it would play a not terribly large role in 1890, nor did it matter in the war against the Philippines. Now, that said, it wouldn't be questioned again until really the Second World War. In June of 1942, 6 months after Pearl Harbor, Richard Quirin and 7 other members of the German armed forces were secretly put ashore in the United States. They had been trained in the use of explosives and secret writing as a sabotage school near Berlin, and 4 of the saboteurs were transported by a German submarine to the Amagansett Beach in Long Island, New York. They landed on the cover of night, carrying supplies of explosives and incendiaries, including some time-delayed detonators disguised as fountain pens. At the moment of landing, they wore German uniforms, but immediately afterwards, they would switch into more traditional American civilian dress and bury the uniforms on the sands of Long Island. The remaining 4 who've been trained in sabotage school were taken to another German submarine to Point Verde Beach in Florida, where they went through the same procedures as those who landed on Long Island and proceeded to go to Jacksonville. They had all been instructed to destroy war industries in the United States. But one of the saboteurs turned himself in, and the other 7 were ultimately arrested by the FBI in New York or Chicago. The decision to try these saboteurs before a military commission was not made immediately, but it did occur. When FBI agents interrogated the saboteurs, the agents assumed the prosecution would take place in civil courts. But as the government's lawyers began to look into criminal prosecution in civil courts, they realized that the saboteurs might face a maximum sentence of only 2 years in prison. And that was pretty much for their conspiracy to commit sabotage. Under the law of war, they could face the death penalty. So a public trial would also expose the apparent ease which the 8 landed on U.S. beaches, therefore incentivizing the Germans and perhaps the Japanese to do it again. And if it came out that the FBI caught them so quickly because one of the men turned themselves in, the Germans may try again. Without a public trial, the Germans would believe that the FBI managed to discover and arrest the saboteurs almost immediately. So what does the government do? At the advice of Attorney General Francis Biddle and Secretary of War Henry L. Stimson, and President Franklin Roosevelt, pictured here, appointed a military commission to try Quirin and his cohorts for offenses against the laws of war and the Articles of War enacted by Congress. This executive order established the commission, also directed that the defendants had no access to civil courts. So the trial took place on the 5th floor of the DOJ building, and Attorney General Biddle himself would prosecute the case. While being tried in military commission, 7 of the saboteurs petitioned the Supreme Court for review of the procedures which they were being tried. The Supreme Court did convene in a special instance for this case, and they argued that civil courts throughout the United States were open at the time, and that though there was no invasion in any part of the country, and that even though knowing that there was a precedent from Milligan that there could be no trial by military commission while the courts were open, and even in noting the fact that one of the petitioners had an American mother, courts still announced that it upheld the government's decision to try the saboteurs in a military tribunal. They were found guilty, and this opinion pushes back on Milligan, distinguishing it that even though civilian courts were open and that one of them may have been an American citizen in some instances, their status as a spy for a foreign nation with which they were at war allowed the saboteurs to be brought before a military tribunal. Remember, by comparison, Milligan had never served in any sort of operation or organization for the Confederates or any other foreign nation. In another case, also occurring during the Second World War, the following attack on Pearl Harbor, Territorial Governor of Hawaii proclaimed that the islands were under martial law and suspended habeas corpus. And when the territorial governor allowed Walter Short, commanding military general of the Department of Hawaii, to exercise all powers which were usually exercised by the governor and territorial judges, it took only until December 8th for General Short to notify the Chief Justice of the Territorial Supreme Court that all courts in the territory of Hawaii were to be therefore closed. So that was a lot of words. Let's take that and shorten that down a little bit. After Pearl Harbor, the governor of Hawaii suspends habeas corpus, says it's under martial law, and the military general kind of overseeing this says, well, if we're under martial law, can't have the courts open, which kind of helps work around that proclamation from Milligan. So this is an effective way in some respects to do so. Without an open court, military tribunals could try civilians. And though other portions of the Milligan holding in the area would say that this is a theater of war and that Hawaii was under realistic attack until 1942, the military will keep tribunals going in Hawaii through 1944, and when it was lifted by FDR. The Supreme Court was decidedly not pleased with this, as Justice Stone will note in Duncan v. Kanahanamoku, that if bars could reopen in Hawaii nearly 2 months after Pearl Harbor, then surely there was no reason why civil courts couldn't stay open as well. So you can see that there's this long-standing broad impact of kind of Milligan in the shadow of how people are going to have to try and work their way around this to allow, military necessity to allow wartime tribunals. And this is a perfect instance of how that was done. Ultimately, it should be noted that each case mentioned came out after the darkness of war had begun to dissipate. So remember that, Ex parte Milligan happens in 1866, after the Civil War ended, and Quirin and Duncan also will occur after the end of the wars. So the leaders and legacies of the Civil War case Ex parte Milligan live on, although in a diminished fashion from what Justice Davis had imagined. Milligan's counsel, James A. Garfield, would go on to serve after all as President of the United States for a scant 200 days, and Garfield's legal career would be made by Milligan. It was his literal first case he had ever tried. And he'd later say that the men he had represented were paupers and prisoners. He'd even paid him for printing his own brief and his own argument. And though he never saw the man and never had any relation with them, he never received $1 for their services, which admittedly Garfield would gripe on because Mr. Milligan was more well off than he had originally figured out. And so Garfield would, from time to time, try and solicit Mr. Milligan for funds. But it did give Garfield immediate standing in the United States Supreme Court and brought him cases that ever since he was able to do from 2 to 7 cases a year in the Supreme Court. It would net him a decent income for the rest of his life, and it made him kind of another piece of who he was as a Supreme Court litigator. So you might be wondering yourself, though, whatever happened to Milligan? So he's released, he goes back to practicing law, and he sues the government for damages for the military arrest and the trial. And the federal court will actually go back and forth, and they will rule in his favor, even though the legal representation of Benjamin Harrison was against him, another future president. Milligan did run into an issue, though, even though he won the moral victory, which is that federal and state statutes limited the amount of damages awarded to Mr. Milligan to just $5 plus court costs.